My name is David Gallo. I'm the director of the AIFC Academy of Law, and welcome to all of our guests from around the world who have joined us today. We are live in Nur Sultan, Kazakhstan, and we're very pleased to bring to you today's webinar. This webinar is part of a series of webinars that have been developed and are being delivered under the AIFC Academy of Law. Our mission at the Academy is preparing lawyers for international commercial law practice. We are really looking to provide unique and valuable legal education experiences right here in Nur Sultan at the AIFC, but experiences that will have global value for practitioners here. As we know, the AIFC is a common law English language legal jurisdiction. We operate in the context of a broader civil law tradition, both within Kazakhstan and across the CIS region. And these various legal systems operate in an independent, but really in an intertwined and interdependent way in some manner, as we together have one goal, and that is for the long-term economic development of Kazakhstan and providing the legal platform with practitioners who are prepared to operate in an increasingly complex global legal environment. So today we have a very exciting program called Listings on the London Stock Exchange and the Astana International Exchange. Just by way of overview, we have two speakers today who I will introduce momentarily. These speakers will discuss the unique features of listings and dual listings on the London Stock Exchange and the Astana International Exchange. We'll talk about processes, procedures, and documents associated with listings. We will also discuss certain specialized topics like premium listings, global depository receipts, and other relevant concepts. Today we have two speakers. One is from our very own AIFC Legal Advisory Council, and the other is from the AIX. And we purposely combine these two fabulous expert speakers with a view toward combining the best of international expertise with the best of local AIFC application and perspective. So with that, let me first introduce Mr. Roy Pierce. As I mentioned, he's a member of the AIFC Legal Advisory Council. Roy is another one of our dignitaries who was in the room where it happened. As part of the Legal Advisory Council, Roy was instrumental in helping to develop the entire legal framework of the AIFC. And so you're going to hear firsthand from an expert who probably understands this area from both a substantive and a practical standpoint, arguably better than anyone else in the world. Roy was in that room where it happened. He's also a partner at Baker & McKenzie in London and a member of the firm's capital markets group. He joined one of the top law firms in 1996 and had an opportunity to work in the firm's Almaty and Moscow offices. Currently, Roy advises in investment banks and issuers on debt and equity capital markets transactions and debt restructuring, with a focus on securities offerings from emerging markets. He's also advised on a number of cross-border mergers and acquisitions, joint ventures, and investments, principally in the mining, petroleum, and power industries. Our other speaker today is Eugenia Bogdanova. Eugenia is the head of regulation and compliance at the AIX. She has more than 20 years of experience working in international capital markets. Before joining the AIX, Eugenia had led legal international business and corporate governance teams at Renaissance Capital. Prior to that, she practiced law at one of the major global firms, White & Case, in Moscow, advising in connection with cross-border and domestic equity and debt offerings. She also focused on M&A transactions, corporate restructurings, information disclosure issues, listing requirements, and corporate governance. So with that, let me please turn the floor over to Roy Pierce. Roy.
David, thank you very much. And ladies and gentlemen, welcome to the session. We will try and keep it interesting. So as David explained, a huge amount of work has been done in Kazakhstan and in particular in Nur-Sultan to make the regime attractive and world-class, and a lot of collaboration has been done by looking at best practice around the world, including taking away whatever is best from the English common law practice and elements of best practice in financial centres around the world. So it really is a very exciting new venue. Now, we're going to talk about quite an exciting topic for companies and their advisors, which is listings and going public via an IPO. We're going to focus a little on London. Why London? Partly because to some extent, any IPO process anywhere in the world will follow a reasonably standard timetable with reasonably standardized documentation. Very often it uses English law, and the same banks will typically appear as underwriters in any major IPO. London is a very deep pool of capital. It has a very extensive banking and support community, including lawyers and accountants and IR consultants and tax advisors. It's also been traditionally quite an attractive venue for companies from the former Soviet Union, and indeed a number of companies from Kazakhstan have listed on the London Stock Exchange. The exchange and the UK regulators are very familiar with this part of the world, so they are used to dealing with listing applications from Kazakhstan and the near abroad. We're also going to look at the AIX rules, and we'll compare and contrast, or indeed see how those are indeed quite similar. So maybe we can move on to the first substantive slide, please. So the agenda here, we will talk about some pre-IPO considerations. What do you need to think about before you go public? What do you need to sort out? Then we'll talk about how the IPO process runs, and we'll then drill down on some general listing requirements. So if we could move on to the next slide, please. Starting with pre-IPO considerations, and the next slide, please. So, when a company decides to go public, it can be for a number of reasons, either because it wants to raise capital or because it's a logical next stage in the company's evolution. Going public will bring a number of benefits in terms of the ability to raise capital and also to increase the company's profile and reputation. But it also comes with a number of risks. As a public company, you are going to be subject to continuous disclosure regime and potential regulatory or even litigation risks. So before you take the step of appointing advisors and launching your IPO, you need to really very carefully consider your corporate structure, your diligence, your customer relations, the structure of your board, and are there any problems that could potentially bar the IPO or at least hinder the timetable, and try and remove any obstacles. So what do I mean by that? Well, companies that come to market often find that they've got a number of different operating subsidiaries with licenses and assets maybe spread across a number of different companies. Not all of them may be wholly owned. They may not have perfected title to all of their assets. So we found pre-IPO companies might not have actually got perfect title to their land. They may have problems with their mining licenses. They may have unregularized anti-monopoly approvals that need to be finalized. There may be litigation going on. If there is litigation going on, that it will have to be disclosed when you go to the public markets. It is a perfect opportunity for anyone in a dispute to extract maximum advantage from you if they realize that they have some leverage over you. So Any litigation out there needs to be wrapped up, if possible, before the IPO happens. You may need to get waivers from your lenders or your counterparties. You will need to ensure that you've got sufficient audited financial statements for 1, 2, or even 3 years, and you've got a clean audit report from a recognised audit firm. You need to look at your corporate governance regime, check whether it's suitable, appoint independent non-executive directors, put in place board committees, and also, very importantly, for your current and future directors, you need to get directors and officers insurance against the risk they will face of being sued by investors or regulators. So overall, the aim at this stage is to remove any problems that could hinder the IPO or prevent it from taking place, to maximise the value of the listed company, and to streamline the IPO process. Because once you do appoint advisors, the process moves very, very quickly, and it will take a huge amount of management time and effort. So the more that you can do upfront, the better. Next slide, please.
And actually, if I may add, like a practical observation, that what we see at the exchange when we start like coordinating with potential issuers, that not all of them realize that they need to engage auditor at a very early stage. And specifically for Kazakhstani issuers, what we see that we do not always see kind of auditor meeting qualification and competence requirements. So the issuer should be very careful in selecting a proper auditor, because financial disclosure is a very important part of the disclosure for investors to make their investment decisions. And auditor is a kind of independent third party confirming that disclosure. So auditors should be engaged at a very, very early stage, and issuers should think about their kind of financial disclosure. And governance, corporate governance, also very important because that may significantly delay the admission process, because all the board committees, independent directors, yeah, all those issues should be sorted out at very early stage, and it takes some time to find right people.
It absolutely does. It absolutely does. And not getting the right people on board and getting them on board sufficiently early in the process is one of the most common reasons why issuers have problems with IPOs. And we'll talk a little bit more about corporate governance on one of the next slides. Now, this slide here just illustrates how some companies approach pre-IPO business restructuring. And the aim here, you might have quite a wide group of companies within the structure. Some of those may be side businesses, not core businesses, that don't really contribute any value to the listed company. And so if you do have that kind of structure, for example, a privatized group may have hospitals, kindergartens, social infrastructure on its balance sheet, which is not going to contribute any value to the listed group post-IPO. You may need to go through a process of disposing of those side or non-core businesses. And you'll also want to make sure that any revenue generating businesses are within the group that forms the issuer's consolidated group post-IPO. So it's all about disposing of any non-core assets or any problematic assets, but making sure that any part of the business that generates the revenue is captured and consolidated within the business. Now, next slide, please.
And to add on the corporate structure, like one side is like clear and transparent corporate structure will help with the valuation, and also very complex structures may have like downside with IML clearance, because at the exchange we will be looking at the corporate structure to understand how it's organized, and when it's unreasonably complex, that would raise red flags for anti-money laundering compliance.
Absolutely. People will want to see a totally transparent structure that you can readily explain to investors. And the last thing that we want is any part of the business to raise any kind of red flag, either at the application stage or post-IPO. Now, we'll talk a little bit about the appropriate exchange. When you start the process, you need to think, where do you want to end up? You may have a firm idea that you need to list on the AIX because this is your home jurisdiction, or a market which is available, exists, is set up specifically for businesses in Kazakhstan and elsewhere. But you may also look at foreign exchanges. And as I said, for issuers from this part of the world, London has traditionally been quite an attractive venue in terms of access to a deep pool of capital. And as I said earlier, a very experienced business community that can help issuers that approach the market and list for the first time. Within London, there are different venues, and we'll talk about those later. But there are alternative markets that issuers from this part of the world have also considered, including Warsaw, New York, Hong Kong, Toronto, Singapore, and Frankfurt. All of those exchanges have their own eligibility criteria. Some of them are named to have expertise in particular areas. So, for example, for oil and gas companies, Oslo, for example, can be an attractive exchange. New York is often seen as a very attractive exchange for tech companies, for example. But they all have capitalization requirements. They all have separate requirements in terms of the financial statements that you need to include. The costs of listing vary from exchange to exchange. And of course, they all have somewhat different regulatory requirements. Next slide, please.
And yeah, before we go to the next slide, and as Roy mentioned, basically for all Kazakhstani issuers, it would be mandatory to open an offer for domestic investors. And like advantages of having AIX as a venue for such mandatory domestic offering in the context of like dual listing at London Stock Exchange and AIX, or Hong Kong Stock Exchange and AIX, like the benefits that AIX regulatory framework is based on principles of English law, as Roy mentioned, and all the documents, disclosure documents, will be prepared in English. So if you file documents in English with the London Stock Exchange, basically you do not need to translate anything to do offering in Kazakhstan on AIX. So you file almost the similar documents with AIX. And AIX will recognize international prospectus prepared for offering for placement on London Stock Exchange, Hong Kong Stock Exchange, AIM market, and Euronext. AIX will recognize ongoing disclosure standard post-listing on those exchanges, and issuers will not be required to do additional disclosure beyond those disclosures such issuer make on the recognized exchanges, provided that the same information released on AIX at the same time as they do on recognized exchange.
That's a significant advantage. I've advised a number of companies that have done IPOs in Poland. Some of those have involved a dual listing and offering to international investors, but also a mandatory listing on the Warsaw Stock Exchange and approval by the local regulator. That process is subject to the regulations of the Warsaw regulator and requires a Polish language prospectus. It significantly increases the legal costs and the time involved in preparing for an IPO. So the ability to use one set of English documents drafted to the same standard really is a major advantage. We mentioned corporate governance, and Evgeny rightly highlighted that that is absolutely key, and the regulator will put a lot of focus on checking that the issuer has the right corporate governance structure in place. Why? Because it's essential to protect shareholders' rights to understand that there are suitably experienced directors with oversight over the business. It's important to ensure equitable treatment of shareholders, and that in particular is what the independent non-executive directors are there to do. The board must be truly independent, not simply doing what it's told by the founder of the business, but really assessing what is in the best interest of the company, the shareholders, and all of the stakeholders, and making sure that there is a transparent disclosure culture within the business, so that anything that needs to be disclosed to investors, both prior to IPO and post-admission, is correctly identified and is then disclosed to the market, so that shareholders have access to all the information they need to make their investment decisions. Next slide, please. I'm not going to talk too much about the UK Corporate Governance Code because it could form a topic in itself. I'll briefly mention it because if you are seeking a premium listing in the UK, you must comply with it or explain where you don't comply and why. And it's often seen as a benchmark even for companies that are not required to comply with the UK Corporate Governance Code. So you might find, for example, a Kazakhstani company not seeking a premium listing will try at least to adopt the main elements of the Corporate Governance Code. And what does that require? It means re-election of directors on an annual basis. It means ensuring you've got an appropriate balance of skills, experience, and knowledge among your board members. You must have independent non-executive directors. You must have one member of your audit committee with relevant financial experience, often from an auditor. It is very well understood what is an independent director and what is not an independent director. Non-executive directors shouldn't be remunerated with share options, and you should split the role of chairman and CEO to make sure that you don't have any one individual becoming too dominant on that board. And increasingly, it is very important to demonstrate to investors that you have got a diverse board, including an appropriate level of female and male representation.
Yeah, on corporate governance, actually in AIFC we have best practice standards introduced in market rules, and we also apply the approach comply or explain. And basically that approach recognizes that there is more than just one way to comply with the principles to achieve sound governance. So basically there are no like very strict or narrow framework for that. There are just kind of guidelines on like best practice corporate governance in AIFC.
Good. Let's move to the next slide, please. Now we're going to take a little bit of a dive into the IPO process itself. Next slide, please. So this is just to give you an idea of how many people are involved in a securities offering. Right there at the center, you have the issuer, the company which is going to apply for admission. It will have its own counsel. You may have a shareholder that's selling shares as part of the IPO to raise funds. It may have its own counsel. You will have underwriters, banks that will assist in organizing the process and helping to find the investors. They will have counsel. In some cases, you might have a depository bank, and we'll explain what that is. They'll have counsel. You have an auditor, and we've talked about how critical that is. Some cases in the UK, you have a bank that acts as a sponsor. I'll explain later. And of course, the regulator and the stock exchange will be involved. I guess the good news is that for all you lawyers or future lawyers, there's a lot of work for lawyers in this process. So maybe move on to the next slide, please. So appointing advisors, how do you do that, and how do you choose them? when looking at your investment banks, you'll look at their general reputation and their access to markets, and also consider their costs. Some banks are more expensive than others. You'll want to check that they've got relevant experience in your particular industry, whether it's mining or real estate, and that they've got an experienced team. Accountants, again, as already mentioned, it's critically important to make sure that you have got auditors who understand the process. So in many cases, that will be one of the big four or one of the larger firms like BDO Grant Thornton. Lawyers, again, it's important to make sure that your legal team has experience doing IPAs for issuers from your part of the world, and ideally experience with people operating in your industry. And often you'll want to hire IR and PR advisors. If you're going public, you won't necessarily be very familiar with how to deal with the market, how to deal with questions from journalists or the media, so they can add a lot of value to the process. Next slide, please. Now, you need to think carefully about what approvals and authorizations you will need. So at a basic level, if you're going to be issuing shares and offering them to the public, you may need authority to increase your share capital. You will need to enter into an underwriting agreement with your banks. That may be a major transaction for the company. And you need to have corporate approvals in place for the listing, for the prospectus, and for the terms of the offering.
Yeah, and the last one, that is the kind of main concern for the exchange. So we'll pay attention to this part of corporate approvals, that the listing and prospectus and the offer terms are properly sanctioned or authorized by the board or shareholders, depending on how the competence split between the governing bodies. And on AIX approval process, the good thing that if you decide to do offering in AIFC or from AIFC jurisdiction, in that case, all your interaction on regulatory matters will be with AIX, because our kind of integrated regulator, Astana Financial Services Authority, has delegated certain authorities to exchange, and exchange also acts as a self-regulatory organization and has power to approve prospectuses, to take a decision on admission to listing, and that means that you will not interact with National Bank of Kazakhstan or new agency for financial markets. And AFSA is also involved in the approval process, but there is no requirement for issuer to apply to AFSA directly. Basically, this is done by AIX. So we do share the file and our assessment report with the regulator, and the regulator has 1 week for exercising the stop order right. And in case the regulator is silent on the file, it means that we have green light to continue with admission to listing.
Excellent. Should we move on?
Yep.
Okay, Jeff, next slide, please. Great, so now we'll talk a little bit about the main listing document, the prospectus or the offering memorandum. If you are a lawyer working on an IPO, you are introducing your client to the market. Up until now, it's been a private company. It may have been regularly producing audited financial statements. It might have a website. There might be more or less information which is publicly available or available to your counterparties and customers, but you will not have anything like the level of detail that an investor needs to make an investment decision, in other words, to decide to buy the shares or not, and that a regulator needs in order to decide whether or not this applicant is suitable and fit to be listed on its exchange. And so you prepare a prospectus, which is a very long document that contains full disclosure all about the business, the products, the history, the strategy, the corporate governance framework, the financial results and condition, and all material risks that could affect the issuer or the market or the industry. All that must be disclosed. The prospectus is a disclosure document and a marketing document. What do I mean by that? As I said, it has to have full disclosure on the business so that people can make the investment decision and the regulator can decide to approve. But it's also used when marketing the securities. So when the investment banks start approaching investors, they will be talking about what a great opportunity it is, what a fantastic business model you have, all the good things about your strategy and why it is that your company is going to succeed. So it's a marketing document, but on the flip side, it will have very detailed discussion of all the risks, a very realistic assessment of all the risks. What could go wrong? How could you lose money if you invest in this business? It must satisfy the regulatory requirements. So AIX or London Stock Exchange will have their own rules that says what has to be in that document. And they will go through a process of reviewing it until they're comfortable before admitting the company.
Yeah, basically AIX operating under disclosure-based regime, and prospectus would be the heart of the listing package. So, and the most of the time we will spend on the disclosure document, and that is the most important document. And basically our rules say that you can't market your offering unless it's done on the basis of the prospectus. So you still may use other documents like roadshow presentations or like some pitch documents, but all of them should contain a reference to published prospectus, because investors make their investment decision based on information disclosed in the prospectus.
Yeah, and I'm going to show you a very scary slide now. So Jeff, if we can move on to the next slide. This is essentially something that we always discuss with management and with directors at an early stage in the process, because they'll often say, well, you lawyers, you go off and draft the prospectus and file it with the regulator, and we'll read it at some stage. And we say, no, you will read every single draft and you will read all of it, because you are liable for it. It is your responsibility. If it doesn't say something that it should say, or it says something wrong or misleading, the directors and the company will be liable, and they could be fined, and they could face, in some cases, criminal liability. So here, I've put up the responsibility standard that applies in the UK, and it really is common sense. The prospectus needs to have all the information necessary to enable investors to make an informed assessment of the assets and liabilities, financial position, profits and losses, and prospects of the issuer. It should be presented in a form which is comprehensible and easy to analyze. So it should not be drafted as if it was written by a bunch of lawyers, even though it is written by a bunch of lawyers. The idea is to put it in plain English, and to put it in a logical and consistent style so that someone can pick it up and understand it. So don't use 20 complicated words when what you are really saying is, we are a mining company in Kazakhstan. Mining is a risky business. Things can collapse, they can get blown up, licenses can get withdrawn, all kinds of things can go wrong. So you write that in a very, very clear style. Responsibility for that document rests with the issuer, the directors, and anyone else who's accepted responsibility. So the auditors can be responsible for the financial statements. If you have an environmental consultant or an oil and gas consultant or a real estate consultant, and they allow their report to be disclosed, they again can be liable. So essentially not just your clients, but any third-party advisors. Next slide, please. So liability, again, this is a conversation we have very early on with management and with the directors. Directors potentially may be personally liable to compensate investors who suffer a loss. So if you as a director know, for example, that there is a problem with your license, or you know that there is a significant risk that you are going to face a multi-million-dollar lawsuit because of something, and you do not disclose it, you may be personally liable for that failure. You could have civil or criminal liability. You do have a defense though. So if a director can show that he or she reasonably believed that the prospectus was true or something was omitted, but there are reasonable grounds why it was omitted. In other words, there is no way the director could have known about that fact. And they've made reasonable inquiries to check that the prospectus is accurate. If they can satisfy that, then they should be able to avoid liability. And so a large part of what we do as lawyers is not only to help the company to draft that prospectus, but we also verify it. And in the United States, there is a concept of doing due diligence, which is the lawyers going through drafting sessions and diligence sessions, asking repeated questions to check with management that everything they write in the prospectus is true and correct. In the UK, there's a slightly different process where we verify the document by preparing backup sources and checking all the statements and getting the directors to confirm the statements are accurate. It's a long process that can take 2 to 3 months and runs throughout part of the listing. So next slide, please. Other documents, I won't spend too much time on this. It is a document-intensive process. There will be an underwriting agreement between the issuer and the banks, where the banks undertake to seek to place the security payable to the underwriters and also make various representations to the underwriters that as a company, you have made full disclosure of everything in the prospectus. In the case of the AIX, there will be a separate listing agreement between the issuer and the AIX itself. And I think possibly unique to AIX, Evgeny, there may also be a book building agreement.
Yeah, basically we offer that option to run the book on AIX infrastructure. So there will be a separate agreement between like one leading book runner and AIX. But those processes kind of run in parallel. It is not like prerequisite for listing or offering. It's like optional thing which issuers and their book runners may use. And what we did on the recent offerings, basically there were several books like for retail investors and institutional investors open in London and AIX. And basically at the end, all the kind of results, book building results, being consolidated by the book runners and decided how the allocations defined.
Yeah, for those who are not familiar with the process, an IPO can often take 5, 6, 7 months. A lot of the work, as we've discussed, is done at the preparatory stage, getting the company ready for the IPO, drafting the prospectus, putting the corporate governance framework in place. Once you get into the review process, you then file multiple drafts of the underwriting agreement, and the prospectus goes to the regulator, which provides comments, is rewritten and refiled until the regulator confirms that it's happy with it. And then while that's going on, the banks are also developing a strategy for which investors they're going to market the securities to. And they will conduct a series of roadshows together with the company where they will introduce management to their investor base so that the investors can ask questions and decide whether or not they want to participate. If they do, then there is a book building process where the investors will indicate whether they're interested in purchasing shares, and if so, at what price. And that's what we call book building, where the banks help to build up the book of investors. And then when the shares are listed, they're then immediately on-sold to those initial investors.
Yep.
I won't spend any more time on this slide because we need to move on. So Jeff, we can go to the next slide, please. So financial statements, very briefly, in most cases, you will need 3 years of full audited financial statements for a London listing. There are other listing venues where that is not a requirement. So for example, if you are a mining startup company, you don't require 3 years of audited financials, but you won't be eligible for main market listing in London. If you have made a major acquisition or a major disposal in recent months, you may also need to have your auditors prepare pro forma financial statements. So the auditor and accounting work stream is quite a significant part of the IPO process.
Yeah, and in AIFC, depending on the instrument and segment you want to list, requirements as to financials vary from 1 year to 3 years. And for main board, like public equity and public debt instruments, usually it's 3 years. And for wholesale bonds, for pre-IPO segment, for junior mining companies, it's 2 years. And recently we adopted new set of rules for so-called regional equity market segment, which is targeted at medium-sized businesses in Kazakhstan and Central Asia. And for those companies, we will require only 1 year financials, audited financials.
So there's quite a lot of flexibility there, you can see. Jeff, can we have the next slide, please? I'll briefly mention depository receipts because these are quite commonly used, again, by issuers from Kazakhstan and the region. As an alternative to listing shares, you can list securities which are called depository receipts. Those essentially are separate securities. They track the underlying shares and they evidence beneficial ownership. They're often quoted and traded in US dollars, and they can be listed in London, New York, or indeed on the AIX. Why would you do that? Initially, they were developed for the US market, and the idea was that if you were a US investor and you wanted, for example, to invest in a French company, but there were certain language and tax difficulties, you wouldn't necessarily understand the company's materials, you don't necessarily want to get paid in euros, you want to get paid in US dollars. The depository receipt is a separate security which is issued by a depository bank. The depository bank acquires the shares from the issuer, and then the depository receipts themselves are listed as a separate security. And the holders essentially receive dividends via the depository bank, not directly from the issuer. It's a very common way of going public that has been used by a lot of businesses, particularly in frontier and emerging markets. Next slide, please. The only thing I'm going to say here is that if you do have a depository receipt structure, you will have a depository bank involved in the process. That can actually be quite helpful for issuers because they will take a lot of the regulatory burden in the process, and they will in some cases also cover the legal costs. I think that's probably all we want to say about that at this stage. So next slide, please. So move on now and have a look at the general listing requirements. And the next slide, please. Now, in London, as we've mentioned previously, there are different segments of the market. I'll just briefly mention the options here. We have essentially 4 categories. Premium listing is the option that was previously only available to UK companies. And unlike a standard listing, that includes much stricter eligibility requirements, and it includes much stricter continuing obligations once you are listed. Now, the benefit of that is that equity investors will have additional protection and additional insurance that because the company can meet these rigorous continuing obligations, they have more downside protection, there is more information available to them, and there are more limitations on the company's ability to engage in major transactions. The benefit of a premium listing in the UK is that if you are eligible to go into one of the FTSE indices, you've probably heard of the FTSE 100, FTSE 250, a number of large funds will automatically invest in you. So commercially, it's quite an attractive option if you can meet the criteria. For those who don't want to or can't, there is a standard listing option where the criteria are essentially those that apply throughout the EU. And then we have our own mid-cap, small cap market in the UK called AIM, and that's often used by companies that are startups, mining companies in the early stages of exploration with no revenue, for example.
Yeah, and for AIX, basically, AIX main board requirements are pretty similar to LSE premium listing requirements, and standard listing at London is matched by AIX regional equity market segment, with certain exceptions. As I said, that for RAM issuers will require only 1 year financials, and free float threshold is reduced from 25% to 15%, but the rest it's pretty much the similar.
Yeah, so you can all look at the slides. I won't go into that in detail. Now, Jeff, can we move on to the next slide, please? So the regulatory landscape, again, is particularly important. Once you go public, you are subject to a very strict regulatory regime, and a number of different regulators may be relevant. In the UK, the main regulator is the Financial Conduct Authority. If you list via a UK parent company, then the takeover panel will also be relevant, and UK takeover rules might apply to you. In Nur Sultan, obviously, we have the AIX and AFSA.
Yeah, acting in coordination with Astana Financial Services Authority.
And then we have other regulators such as European Capital Markets, ESMA, and the US SEC if you are offering to US investors. Slide 23, please. Again, I won't go through that in too much detail, except to say you can see there that there are a number of different rules that you have to think about in the UK, including listing rules, prospectus rules, and then ongoing disclosure guidelines and transparency rules, as well as takeover rules. In the case of AIX, we have AFSA. Yep.
In AIFC, we're always improving and trying to make our regulatory environment more kind of friendly, but still robust and like transparent. And we just, at the end of June, we just finished the big reform of market rules in coordination with AFSA. So the link is to the new kind of amended and restated version of the market rules. For AIX business rules, those were approved this week by AIX board, and we're expecting the final approval from our regulator probably next week. So this link is to the old version of the business rules, and by the end of July we expect to publish the new set of rules. But some information is available at our website in section public consultation.
Yeah, it's important, I think, to bear in mind that these rules are not static. So this is this applies generally. It's also the case in the UK. Clearly, following Brexit, the UK may diverge further from the current situation, which is that we have European-wide rules that that we follow in the UK. That the UK may diverge beginning next year. We'll see. Regulators and stock exchanges are constantly in dialogue. There's a lot of dialogue in the UK between the regulator, the London Stock Exchange, and market participants, including banks and investors. So it's an evolving landscape. Next slide, please. Now, in the UK, we have essentially listing rules, disclosure and transparency rules, and currently the European-wide market abuse regulation. All of those create potential liability for companies and for their directors, and breaching those rules can result in censure, which is telling the market that you've done something bad, or fines, or even potentially cancellation of listing. Rather than going through all of them, I'm going to mention one that is the one that we are most frequently asked. So once companies have done their IPO and they're now listed, they are subject to a continuous disclosure regime, which means that at all times, they have to monitor the situation and determine whether they have any inside information. In other words, any information which is not known to the market, and which, if it were known to the market, could have a bearing on an investor's decision whether or not to buy or sell those shares. So to give you an example, if you are an issuer which has a mining business and you lose one of your major suppliers or customers, or there's a disaster at one of your mines, or there's a sudden deterioration in the world market price for your commodities, you need to make sure that that has been disclosed to the market. And the question you always ask yourself is that information something that I would want to know if I were a shareholder? And if the answer is yes, it must be disclosed, and it must be disclosed immediately. Same day, even potentially within an hour or two of you finding out. And that's why we said at the beginning, corporate governance is so critical, because you need to have a system in place to ensure that management and the directors can monitor information on an ongoing basis and ensure that information is being disclosed to the market. That is the absolute key to life as a listed company once you've done the IPO. Now, can we have the next slide, please? Listing principles. I mention this purely because the listing rules are backed up by a series of principles, including that issuers have to take reasonable steps to ensure their directors understand their responsibilities, that they've got procedures, systems and controls in place, that issuers act with integrity to holders, that they communicate in such a way as to avoid a false market. They treat all holders of the same class of securities equally, and they deal with the regulator in an open and cooperative manner. So where we sometimes find a company might come to us and say, we've got a concern, we think we might have breached the listing rules inadvertently, or we think we found some inside information that we should have known, but we didn't disclose it on time. Or we think someone in management has been dealing in shares based on inside information. you need to move very, very quickly to investigate, and then you need to contact the regulator and say, we think there's a problem, this is what we think is going on, and this is what we're doing to address it. Now, those listing principles are designed to ensure that if a company complies with the letter of the rules, but not the spirit of the rules, they can be fined as well. And so often where a company is in a position where the regulator is alleging that it's breached the rules, if it doesn't cooperate fully, provide information on a timely basis to the regulator, for example, it can be fined not only for the breach of the rules, but also for the breach of the principles. It's partly designed to ensure that clever lawyers don't find a way to avoid blame by saying, well, actually, we followed the rules. You've got to follow the rules, but you've got to follow the principles as well. Next slide, please. I won't say anything about this other than to say that the stock exchange in London also has its own rules and continuing obligations on top of everything we've just discussed. But I think we'll move on to the last slide. So this is just setting out an overview of the principal continuing obligations. Again, you can see that for companies in the UK with a premium listing, there is significantly more in terms of ongoing compliance compared to a standard listing or an AIM listing. So we'll let you read that slide after this call. And then Jeff, move on, please. So Evgenia, can you take us through the aftermarket rules and the AIFC business rules?
Yeah, basically for the offerings, there are two major pieces of legislation: aftermarket rules, which set out general framework for offering of securities in or from AIFC, define scope of prospectus, set out the corporate governance principles, and also contain provisions on how to manage inside information. And at the exchange level, we have our set of business rules, which include various chapters, including listing rules, prospectus rules, admission and disclosure standard, which quite similar what you just explained about LSE set of rules, market disclosure rules. And there are specific chapters and sections for particular segments or instruments, like we have specific regulations for green bonds, junior mining companies, pre-IPO companies. For pre-IPO, this is designed for companies which are not yet ready for kind of full admission and trading, but this is a kind of half step towards full listing and trading, and that pre-IPO segment gives issuers officially they are in the list, but their instruments are not traded on the exchange, but they already have to follow post-admission disclosure requirements. It's a reduced set of requirements, but it's a good kind of way to practice being a public company. Then we have rules for wholesale bonds. We have a segment for Belt and Road market, listed fund rules, and Islamic securities.
Yeah, it's a pretty comprehensive rule book. So I think we have a couple of minutes for questions. I don't know if anyone has been able to send any using the comment facility.
Yes, thank you, Roy and Eugenia. My colleague Almas is behind the scenes, and he is fielding questions that have come in from the audience. And we understand that Almas does have a couple of questions. So Almas, let me turn it over to you.
Yes, thank you, David. We have several questions, and some of our guests want to ask their questions orally. So please turn on raising hand button, and then I will open your mic and you can ask your question. So, and also we have several questions in chat. First is from Baurjan Hamadiev. He is a lawyer. His question is, if I'm correct, most of the local national companies are planning to do IPOs and SPOs at the AIX. Taking into account current situation at the securities market, will these plans be changed or postponed?
We can't comment on issuers' plans. So we read the same sources they do, but even if we know some more information, we can discuss it publicly because it's confidential information. So,
Okay.
but hopefully the market kind of gets back in a normal condition, and we will see not only debt issuances, but also some equity offerings. Like we had one last month by Kazatomprom, and I think it was very successful.
Yeah, I mean, there's a long lead time, and you recall from the first set of slides, there's a lot of things that issuers can and should do before they even start the IPO process. So we sometimes talk to companies, and I was talking to a company, just last week, that says we might do an IPO in 2 years, but what do we need to do at this stage? So they're already thinking about corporate governance, restructuring, tax efficiency, etc.
Yep, okay, thank you. Next question is from Aslan, student from Eurasian National University. His question is, what is the uniqueness of AIX and main difference from other stock exchanges?
Depending on which exchanges we compare to. So if we compare, like for Kazakhstan market, the unique about it is, I said, that AIX operates on the principles of English law, and that kind of makes it attractive for international investors. And AIFC has its own court system, basically independent from Kazakhstani government, which also give additional confidence to international investors to invest into Kazakhstan.
Okay, thank you. The last question. If local company is seeking an external listing for its shares, can the requirement for a dual listing in Kazakhstan be satisfied by an AIX listing?
Yes.
Yeah, I think it's a sensible approach because we said earlier in the presentation, one of the big advantages of AIX is that if you are looking at doing an overseas listing as well, because your capital needs mean that perhaps London is a suitable listing venue, you can use essentially the same set of documents and everything can be drafted in English. That is an important advantage.
Okay, thank you. So we have a bit exceeded the timing. So for other guests, we can say that you can share your questions to our email. We'll be pleased to answer. Thank you.
Right. Thank you, first of all, to Roy Pierce and Eugenia Bogdanova for your outstanding presentations today. Thanks to our audience. We had more than 70 people on the line, which means that this was interesting and relevant, and we hope you enjoyed it. I just wanted to make two final brief comments before we sign off. The first is in relation to a comment that Roy made a few minutes ago in response to one of the questions, which was, if you are a lawyer and you have a client that is now a privately owned company, and they are contemplating maybe somewhere down the line of listing their shares or a portion of their equity, don't underestimate the importance of making sure that you're aware of the disclosure guidelines around the preparation of a prospectus or circular or offering memorandum, because those requirements can actually be pretty intense. And if a company comes to you and says, we want to do an IPO right now, well, you have to hope that they already have in place the various operating procedures, compliance programs, accounting standards, and so forth. You have to hope that they've already done that so that moving forward for the IPO just becomes a matter of getting the documentation together. However, I have an anecdotal story. I worked for a number of years as an in-house lawyer for a large multinational company as a corporate finance and a capital markets lawyer. And we were looking at spinning off one of our sub-businesses. It was actually a small ticket commercial equipment financing business. And when we did our own internal due diligence, we really had to take a good close look at the policies and procedures that were in place at that time. So as an advisory lawyer with a client who may down the road be looking to do an IPO, you could really add significant value to that process right now by making sure that they have put in place the proper procedures so that they could successfully go ahead and launch. The regulator cares about those things, the underwriter, the rating agencies, and so forth. So it's really important. That's point one. Second point, which will be more brief, is this is such a fascinating discussion and a fascinating area of the law. And in particular, it creates enormous opportunities for companies who have registered as AIFC participants to raise capital and to really make a market statement. And we at the Academy of Law are looking to continue this legal education process in the capital markets sector in particular. We had actually a chat about this before the conference started. So stay tuned. We're looking to put together and launching a full course that will lead to a certificate in AIFC capital markets. So stay tuned. We look forward to, we hope, seeing you all again. And again, many thanks to Roy and Eugenia for this fabulous presentation. Thanks to everybody. Stay safe and have a great rest of your day.
Thank you, David.
Thank you, David.
You're welcome.
Bye.